Every one of these is claim one of a real patent, and they come from fields with nothing in common. Each one states a test rather than a description, and every object that's ever been made either passes it or fails it. So what the patent actually owns is the collection of things that pass. And if that sounds familiar, it's because that's set theory. So I want to find out how far that goes and at what point it breaks down. First, we work out what the pieces are, by which I mean everything you'd need in order to describe patent law at all. Then we take those pieces one at a time and write each of them down in set theory, and see how much of the law comes out the other side. And then we'll end with the place where the translation fails. Starting with the pieces, the law has to be able to say 6 things about any claim at all, and every one of them is a question about which objects that claim reaches. The first 5 come in the first half of the video, and the 6th one at the end. So here's a claim, an invented one, for a chair, and the rest of the video runs on it. So run a stool through it. It has the seat, and it has the legs, and it has nothing attached to the edge of the seat, so it meets 2 of the 3. And 2 out of 3 is worth exactly what 0 out of 3 is worth. Every element or you're outside. And that question doesn't only get asked about chairs. It'll answer just as flatly for a rock and a cloud and the moon and every other object in the universe, and for almost all of them the answer is simply no. So what a claim really is a condition you can apply to any object at all, which comes back true or false. The name for that is a predicate, though the word matters a lot less than the thing. And the moment you have a predicate, you've got a set for free, because the set is just everything that satisfies it, which logicians call the extension of the predicate, reasonably enough. So, written down, a claim is a predicate, and what it covers is the set of every object that satisfies it, everything anywhere, made or unmade, not just the chair the inventor built in their garage. That's the first translation, and the rest of the video is built on it. Now go back to that word comprising, because it's carrying the only piece of logic in the entire sentence, and everything from here depends on what it means. The elements of a claim are joined by conjunction. You need the seat and the backrest, and at least 3 legs. Which means the claim set is the set of all X satisfying A and B and D. And a conjunction of conditions is an intersection of sets, so the claim is the intersection of the things with a seat, the things with a backrest, and the things with at least 3 legs. That's the whole mapping. Everything else in this video falls out of that one line. And I want you to watch how much it forces. Start with the seat, which on its own is an enormous set holding everything in the world you could sit on. Intersect that with the backrest, and it gets smaller. Intersect it with at least 3 legs, and it gets smaller again. Every word you add to a patent claim makes it cover less. You're not describing your invention in more detail when you add words. You're intersecting with another set, and intersection can only ever take things away. Which isn't a rule anyone has to remember or a doctrine anyone had to sit down and decide. It's just what intersection does. A dependent claim, the apparatus of Claim 1, wherein the legs are wooden. Everything the parent required, plus 1 more requirement. So a dependent claim is a proper subset, and Section 112-D says so almost in those words that it incorporates by reference all the limitations of the claim it refers to. Then the transitional word comprising is the open one, so a chair with an extra footrest is still inside. Consisting of is the closed one, and that same chair walks free. So those 2 words are a subset condition and an equality condition, and that is why very nearly every claim you will ever read says comprising. Then a Markush group, a material selected from the group consisting of oak, steel, and aluminium, a literal finite set, written straight into the claim. And because any one of them satisfies it, those alternatives are a union rather than an intersection, which is the one place in this whole video where the law reaches for or. And put a number in a claim, a seat between 400 and 500 millimeters above the floor, and what you have written down is an interval. So a further claim narrowing that range to 430 through 460 is a subinterval, which is a subset, which is what we already worked out dependent claims are. So that's the machinery, and it's honestly not very much. Now let's spend it, and the way we're going to do that is to leave the claim set exactly where it is, and only change what a second region means. Let E be everything some other company made, used, offered to sell, or sold in the country. Then that company infringes exactly when the two regions overlap, because if there's a single object sitting inside your claim, that's also something they sold, you've got them. So infringement is a membership question, and nothing more than that. Is the accused product in the set, or isn't it? And that isn't an analogy I'm laying on top of it. The statute says whoever without authority makes, uses, offers to sell, or sells any patented invention within the United States infringes the patent, makes, uses, sells, one object at a time, in or out. Now leave the claim set exactly where it is, and change Y to the prior art, everything already published, patented, sold, or otherwise available to the public before you filed. Your claim is new when those two don't touch, because the moment a single thing in the prior art falls inside your claim, the claim is covering something that already existed. So that one's a membership question too, just asked about a different set. Second doctrine spent, and notice we haven't added any machinery at all, we relabeled one region. And again, section 102 does it for us, in the words on screen. There's an old line in the field, that which infringes if later anticipates if earlier, and it gets taught as a memorable saying you're supposed to keep in your back pocket. But it isn't a saying at all, it's the same picture. Read in two directions. So, third time, and I think you can probably guess the shape of this one by now, take the prior art and grow it by adding in everything a person of ordinary skill could have got to from there without doing anything you'd want to call inventive. If your claim overlaps that bigger set, the claim's obvious and you don't get it. So obviousness is a membership question as well, and it's the same relation the other two were, asked about a bigger set. And section 103 again, doing it for us. So that's three of the biggest questions the whole system runs on, sitting in one picture, and the only thing that changed between them was what we decided to put in the second region. Did you notice us add anything? We relabeled a circle. Twice. Now, obviousness is famously the worst of those three. It's the hardest to predict, the hardest to argue, and the most likely to come down to which examiner you happen to draw. So where did all of that difficulty go? It went into exactly one place, which is that nobody knows how far the hatching extends. The relation is perfectly clean and the set is undefined. And it's got worse rather than better, because in 2007 the Supreme Court knocked down the rigid test that had at least given that boundary a working membership rule, on the entirely reasonable ground that it was too rigid. Now you might say that's a cheat, that I've quietly shoved the hard part inside the definition of a set, and then congratulated myself on how tidy everything else looks, and you'd be exactly right. The difference is that now we know precisely where the hard part went. So let's count up what we've got, because it's more than I expected the first time I did this. A claim is a predicate, and its scope is that predicate's extension. The elements are a conjunction, so the claim is an intersection, and adding words to it can only ever shrink it. Dependent claims are proper subsets. The transitional phrases are containment conditions. Markush groups are finite sets whose alternatives are unions, and numeric ranges are intervals. Infringement and anticipation are both membership questions, and obviousness is membership in a grown set. That's most of a legal system, and how much machinery did we actually spend to get it? 2 operations and 1 relation. Which is the point at which the honest thing to do is stop admiring it, and go looking for the place where it fails. There's a paper by Jeffrey Lefstin from 2008 that pushes this a lot further than anything else I've been able to find, and at one point he squeezes the whole system down into 3 rules. Everything useful may be claimed. No claim may contain anything already in the prior art or obvious from it, and everything inside the claim infringes, while nothing outside it does. 3 rules, and out of them you get patentability, novelty, obviousness, and infringement, which is very nearly all of it. And then Lefstin points out the thing this entire video has been walking towards, which is that those 3 rules say nothing whatsoever about how big a claim is allowed to be. You can ask whether something is inside the set. You can't ask whether the set is too big. There is one more doctrine, though, and it's the one that's supposed to answer exactly that. Enablement, the requirement that you teach the public how to make and use the thing. Section 112A, and it's the enabling clause at the end that matters here. So that gives us another set we haven't used yet. Let E be everything your written description would actually let a skilled person go away and build, without having to invent anything further for themselves. We've got the claim set, we've now got the enabled set, and we've got exactly 3 relations available to us, and one of them is going to be enablement. So which one is it? And this is genuinely the moment to pause, because you have everything you need in front of you, 2 sets, and 3 ways they can sit relative to each other. So see if you can get it before I spoil it. Alright, so the first option says that a claim is enabled when the 2 sets overlap, which is to say, you've taught people how to build at least one thing inside your claim, and that turns out to be enough. Which can't be right, because it would mean that teaching the world how to build a single working example of your idea entitles you to every possible version of it, including all the versions you have no idea how to make. Every claim overlaps its own disclosure somewhere, so that test passes almost everything, and a test that passes almost everything isn't a test. So try the other one, which says a claim is enabled only when every single thing inside it is something your disclosure taught people how to build. And no patent that's ever been granted satisfies that. Not one, ever, because you'd have had to personally enable every variation in every material, at every size, for the full 20 years, including the ones nobody's going to think of for another 3 decades. Containment the other way round says the disclosure has to be smaller than the claim, which is true of very nearly everything and tells you nothing at all. And that's the vocabulary, all of it spent. Well, almost. Because the natural thing to assume at this point is that we've just been careless, that enablement is a little more complicated than the other 3, that it wants some 4th relation we haven't thought of, and that somebody cleverer will turn up with it. So here's a dependent claim. The apparatus of claim 1, wherein the legs are made of neutronium, which is the hypothetical stuff of neutron star cores, and which nobody has ever held, and nobody can make, and nobody is going to make anytime soon. That's a structurally perfect dependent claim. It takes claim 1 and it adds a limitation, which is the entire requirement, and it defines a real subset of the original. And it's enabled by nothing, by anybody, at all. Now you might say that's a ridiculous claim and no attorney would ever file it, which is true, and it doesn't help even slightly, because there's nothing in the statute that distinguishes it from claim 2, the one that added wooden legs. They're the same kind of object. And tribunals have actually run this argument in the opposite direction, reasoning that if a dependent claim isn't enabled, then the parent it depends from can't have been enabled either. Follow that faithfully, and the neutronium claim takes claim 1 down with it. Which forces out the thing that's been sitting underneath all of this. A claim has to cover a set rather than a single object, or it would be worth nothing. But claims cover sets by reciting properties, and they're written in open format, and the result of those 2 things together is that the set isn't merely large, it's infinite. So there's no such thing as a narrow claim, in the sense people mean when they say it. Every claim is a genus, and the difference between a broad one and a narrow one is a difference of degree and never of kind. Lefstin's phrase for this is that all the world's a genus. And this isn't a point about exotic materials or technology that hasn't been invented yet. There are infinitely many chairs you could go and build this afternoon out of things in a hardware shop, and your claim covers every one of them. So courts need some way of saying that a claim reaches too far, and when they do it, I want you to watch the words they have to reach for. One Federal Circuit case held a patent invalid because the disclosure failed to enable, in the court's own words, a significant portion of what was claimed. Significant how, though? Sets don't have portions. You can ask whether a thing is in a set, and you can ask whether one set sits inside another, and neither of those is what that sentence is asking. It's asking what fraction of an infinite collection is any good. Because inside any real claim there are infinitely many things that don't work, and infinitely many that do, along a very large number of axes, most of which the claim never mentions and the drafter never considered. And to ask what fraction of an infinite set has some property, you need a measure, a rule for how much each part of it weighs, and no measure was ever specified. Not in the statute, not in the case law, not anywhere. You probably already know how this goes, because it's the same reason pick a random integer isn't really a question. It parses fine as English. There's no uniform way to actually do it, and the moment you pick a weighting, you've decided the answer rather than discovered it. A significant portion of the claim is that sentence, wearing a suit. So which measure do the courts use? Read the cases honestly, and the answer is that the axis that ends up mattering is the axis the defendant happened to be practicing. Enablement is supposed to be a function of two things: the claim and the disclosure. What it turns out to need is a third input that the law has never written down anywhere, and in practice, that third input arrives along with the lawsuit. Which means the same patent, with the same disclosure, can be valid against one company and invalid against another, not because the evidence was different, but because the measure was. And whether a patent is valid isn't supposed to depend on who you sued. Now step back and look at where all the formal work in this field has actually landed over about 40 years. Literal infringement, anticipation, claim charts, coverage analysis. And then look at where patent litigation actually spends its life and its money, which is claim construction, obviousness, the doctrine of equivalence, and enablement. Those two lists have nothing in common. And I don't think that's a coincidence. And I don't think it's because the second list is harder in some technical sense. The doctrines that formalize cleanly are the ones where the law has already finished deciding what it thinks, and the ones that resist are the ones where the argument is still going on. So the mathematical intractability is a symptom of the unresolved argument rather than the cause of it. Enablement doesn't lack a measure, because measures are hard. It lacks one because choosing it means answering how much an inventor ought to get, and nobody's been willing to answer that in general. I should say plainly that this is one reading of one scholar's formalization rather than anything a court has held, and there are people who'd happily take the other side of it. But I think the habit of thought is worth keeping whether or not you ever read another patent in your life. When you formalize a body of rules and every piece goes in except one, the temptation is to call that piece hard and go looking for cleverer machinery. And usually it isn't hard at all. Usually it's the place where the people who wrote the rules never actually agreed with each other. And what the formalism has done is draw you an unusually clear picture of the disagreement. So can we express patent law with set theory? Most of it, yes, and more cleanly than I expected when I started. A predicate, an extension, an intersection, and three relations gets you infringement, novelty, obviousness, dependency, and the whole grammar of how claims get drafted. And the one place it fails is the one place the system was built to answer, which is how much any of this ought to be worth.